Good afternoon. My name is Dr. Andrew Sanderson, and I'm Associate Dean for Health Equity at the Lewis Katz School of Medicine at Temple University and the current Vice President of the Harvard Chan Alumni Council. I'd like to welcome you to our first Alumni Lunch and Learn series webinar. These webinars will provide us the opportunity to hear from alumni around the world about their current work. I'm extremely pleased and honored to introduce my classmate from Harvard Chan, Madeline Morcelle, to kick off this series. Madeline is a fierce advocate for reproductive rights and an all-around wonderful human being. Madeline graduated with her MPH in 2016 and is currently working as a senior attorney at the National Health Law Program in DC. Prior to this, Madeline was Director of Public Benefits Law at the Mississippi Center for Justice and has a career history of advocating for equitable healthcare access. Today, Madeline is here with us to talk about her current work, defending and protecting non-discrimination rights. We'll have a chance to hear from Madeline and then ask some questions. If you have a question during Madeline's presentation, please share it in the Q&A box. Madeline?
Thank you so much, Andrew. I'm going to share my screen. Good afternoon, everybody. For those on the West Coast, good morning. For those around the globe, hello. Thank you so much for joining. My name is Madeline Morcelle. My pronouns are she, her. I'm a senior attorney, as Andrew said, at the National Health Law Program. I coordinate, among other things, our work on non-discrimination rights in sexual, reproductive, and related healthcare. I also coordinate our work bridging federal healthcare reform and sexual and reproductive health advocacy and our work on some other issues. I'm going to talk today about defending non-discrimination rights in sexual, reproductive, and related. First, a bit about the National Health Law Program, which I joined in 2020. For over 55 years, NHELP has fought for equitable healthcare access for low-income and undervalued communities through litigation, policy lawyering, and advocacy and legal education. Our team works with state and local partners in all 50 states and Puerto Rico, a lot of legal services advocates, sexual and reproductive health rights and justice advocates, disability rights and justice advocates. And we're guided by an equity stance that really puts forth a vision of working towards collective liberation as a value. And in addition, our sexual and reproductive health practice area, of which I am a part, is guided by the Reproductive Justice Framework, which is a women of color founded movement that started in 1994 as a response to the mainstream reproductive rights movements, othering of issues that disproportionately affect Black and other women and queer people of color, puts forth a vision of a right to bodily autonomy, a right to have children, not have children, and raise the children we have in safe, sustainable, and healthy communities. Today, I'm going to outline some of the basics of two civil rights laws that address discrimination in healthcare. I'm going to discuss how the U.S. Department of Health and Human Services, or HHS's 2024 final rules on Section 1557 of the Affordable Care Act and Section 504 of the Rehabilitation Act addressed sex-based and intersectional discrimination, especially in a sexual and reproductive health context. Then I'm going to describe current threats to these regulations and rights and how we're fighting back. First, just some level setting, the hierarchy of law in the United States. Statutes or laws are passed by Congress and signed into law by the president. They can't be changed without enacting a new law. Regulations implement the law. They're developed by agencies. They require generally a public comment process. So the public has an opportunity to weigh in on those regulations. And they have the force of law because they're implementing a law. They sort of spell out the details of what the law means and how it's going to be enforced and applied. guidance is developed by agencies. Generally, there's no public comment process. They can be changed unilaterally by agencies, and this includes things like executive orders and FAQs. The federal rulemaking process begins when Congress grants agency authority via a new law, what we would call enabling legislation. There's what's called a notice of proposed rulemaking that they issue to create or revise regulations. This is basically setting forth like what they're proposing as a change to regulations or as new regulations. It includes what's called a preamble that sort of explains everything, and then it includes the regulatory text itself, which would become the new regulations. Then there's a public comment process. This period is usually between 30 and 60 days from the time that the proposed rule is posted. And then at the end of that period, the agency has to review all of the comments that it received from the public and can revise the rule or choose to conduct further analysis on what they're trying to do based on the comments they receive. Then the agency generally either issues a final rule, which adds the proposed regulatory text or revised regulatory text to the Code of Federal Regulations, or withdraws the rule, decides we're not going to make the changes we proposed. There is an effective date in the final rule where it actually goes into effect. Sometimes that's immediately. Sometimes there's a delay to allow entities that are subject to the rule time to come into compliance. And then sometimes if we challenge a final rule, there's judicial review, there's litigation, and the courts review the legality of the final regulations. Section 1557 of the Affordable Care Act was the Affordable Care Act's non-discrimination provision. This is the first federal law that really broadly addresses discrimination in healthcare, building off of and expanding off of pre-existing civil rights laws. It prohibits discrimination based on race, color, national origin, sex, age, disability, or any combination thereof in certain health programs and activities. It was the first federal law to prohibit intersectional discrimination in healthcare and to broadly prohibit sex discrimination in healthcare. It applies to all health programs and activities that receive federal financial assistance, are administered by entities created by the Affordable Care Act's title on the marketplaces, or health programs and activities administered by HHS. What this means in practice is it covers most health insurance programs and plans, most healthcare providers, and a lot of broader activities as well, like federal research it can cover. The 2024 final rule issued by the Biden administration on Section 1557 restored and expanded upon regulations that the Trump administration had rescinded just years before. The Biden rule restored and revised a definition of sex discrimination, specifying that sex discrimination that is prohibited under this law includes pregnancy or related conditions, sex stereotypes, sexual orientation, gender identity, sex characteristics, as well as intersex traits. And this covers, this covers, for example, intersex individuals. It also included provisions against discriminatory benefit design, such as charging more for prescription drugs that people living with HIV have, more cost sharing for prescription drugs for people with certain disabilities, discriminatory exclusions of coverage for things like assisted reproduction, like fertility preservation or IVF for same-sex couples. this covers situations like that. It also included really critical language access provisions because Section 1557's prohibition on discrimination based on national origin covers people with limited English proficiency. So the 2024 rule really expanded upon all of this. The preamble, which again, as I explained, is sort of the explanation that comes before the actual regulatory text, also included a lot of wins that are relevant to sexual and reproductive health in particular. The 2024 final rule renewed the federal recognition that protections against sex discrimination related to pregnancy or related conditions cover abortion-related discrimination. For example, providers that provide abortions cannot deny access to abortions based on race, disability, or other protected characteristics. As well, healthcare providers just in general cannot discriminate against individuals based on their pregnancy-related decisions, including abortion, whether those decisions were in the past, they're making those decisions now, or they're considering those decisions in the future. There were also so many firsts. We really pushed the administration to recognize for the first time, for example, that obstetric violence, mistreatment in pregnancy care based on race or other protected characteristics can violate the law. And just to give you an idea of the scope of this issue, a 2019 national study of over 2,700 women found that 1 in 6 reported mistreatment, such as loss of autonomy, being shouted at, scolded, or threatened, or being ignored, refused, or receiving no response to requests for help during childbirth. And rates were highest for Indigenous, Hispanic, and Black women. So having this recognition really meaningful that this can constitute a civil rights violation when it's based on a protected characteristic. As well, we pushed them to recognize that discriminatory pain dismissal and denial of pain medications based on sex stereotypes about women can violate the law. And this is actually addressing what is unfortunately a millennia-old issue. Sex discrimination related to pain dates back to the founding of medicine as we know it in the West. It dates back to Hippocrates, who posited that a lot of the symptoms that women experience and complain about were a result of hysteria, a wandering uterus. And actually hysteria remained in the modern DSM as a diagnosis until 1980 in the United States. So sex discrimination around pain is really still a modern problem. And while the language changed after the DSM changed, the issue has continued. Women continue to be labeled as chronic complainers, and symptoms continue to be dismissed. But this really sought to address this issue of, for example, women being more likely to be provided anxiety medications when they complain about pain than actual pain medications. And there's a lot of research and data documenting this problem even today. Section 504 of the Rehabilitation Act was the first federal civil rights law that addressed disability discrimination. It was signed into law in 1973, and last spring, HHS updated the regulations on Section 504 for the first time since 1977. There was a really robust update as a result of a lot of advocacy from the disability community, but I just want to highlight 2 buckets of reforms that I think are really important in this context. First, there's a new provision addressing discrimination in medical treatment. It addresses discriminatory treatment denials or limitations, denials of treatment for a separate symptom or condition on the basis of disability, or medical treatment provision based on an individual's disability. It also addresses the issue of family policing. There's a new child welfare regulation that prohibits discrimination against individuals with disabilities in the child welfare system, including parents, prospective parents, foster parents, caregivers, and children. And this is really important because there's a really pervasive issue of people with disabilities being denied parental rights based on their disability due to widespread ableism in our society. And this is a really pervasive reproductive justice issue. There were, once again, a lot of firsts in the preamble. We pushed the administration to recognize all of these things. And first, they recognized that discriminatory denials or limits on access to screenings for sexually transmitted infections, mammograms, contraceptives, or other preventive care based on disability, these are really pervasive issues, can violate this civil rights law. Forcing someone to receive a sexual and reproductive healthcare service, such as sterilization, including denying informed consent for a medically necessary sterilization because of someone's disability, can violate their civil rights. As well, failing to provide comprehensive information about and access to information about assisted reproduction. Again, this is things like IVF based on someone's disability and a belief that they shouldn't become parents because of their disability can violate their civil rights. And they note in the preamble that all of these situations may also violate Section 1557, which again is a broader civil rights law. And this is really important for addressing intersectional discrimination because if someone is denied assisted reproduction, for example, based on disability and race, this is something that a lot of people with sickle cell disease experience that can violate Section 1557. Unfortunately, we're sort of at a crossroads now with the 2024 final rules on Section 1557 and Section 504. There are a number of cases challenging these civil rights regulations from the far right. And we anticipate new proposed regulations to gut these regulations from the Trump administration for a number of reasons. First of all, doing so was a proposal in Project 2025, which the administration is underway in implementing. Second, they have signaled in case filings that they're going to be updating these rules. And third of all, the Trump administration gutted the regulations around sex discrimination during the first administration, and so it would be consistent for them to do this again. Regulations matter because, I just can't stress enough, regulations matter because they really spell out, again, what laws truly mean. The entire statutory text of Section 1557 is just 5 sentences long. The regulations are quite long and really spell out what does it mean to implement these rights. So regulations spell out the details and give life to our civil rights. In terms of defending our non-discrimination rights in this landscape, first of all, we need to ensure a robust response when they propose new regulations. I'll touch on a bit in the next slide, but everybody will have an opportunity to make their voice heard and push back against the administration during that public comment process that I mentioned earlier. HHS has been rolling back administrative enforcement of these civil rights, which is a really crucial part of HHS's oversight responsibilities. And instead, they have been weaponizing some of these civil rights laws to go after populations such as trans people. But barring acts of Congress and changes to the civil rights laws themselves, Section 1557 and Section 504 remain the law of the land. We will have opportunities when they try and change these regulations to challenge those changes in court. And individuals who are experiencing discrimination under these laws can continue to enforce their rights in federal courts. As well, for health insurance discrimination in particular, people can file complaints with their state insurance commissioners. And this is a link to find your state's complaint portal. Anybody can file a complaint. You don't need to be an attorney to do this. And I just want to stress that your public comments make a difference. The administration is legally required under the Administrative Procedure Act to consider all comments during a public comment period. When they are finalizing a rule, they have to summarize all of the comments they received and whether they made any changes from what they proposed before finalizing the rule. Then all comments that they receive become part of what's called an administrative record and are reviewed during litigation challenging final rules. So it's really important, even though we can expect that public comments probably aren't going to change this administration's mind in terms of what they want to do. It's really important to build that administrative record. Comments have been critical to NHELP's litigation, challenging things that the first Trump administration tried to do regulatorily. So we really need everybody's help building that record. Comments can be as short as a paragraph. It can be about your experiences with healthcare discrimination, your loved ones' experiences. If you're a healthcare provider, it could be your professional experiences. And whatever you want the administration to consider and that you think will be important to litigation later on. And you can stay up to date on developments on this issue by signing up for NHELP's newsletter. I included the link here, and I think Amelia is going to share the link in the chat. We have a campaign called My Care Counts, where we create what are called comment portals to make it really easy for the public to submit their own stories and their own perspectives to be considered. And then we submit those as a batch on the public's behalf to just make things as simple as possible so you can follow along for updates by signing up for our newsletter. I'll also note really briefly for those of you who might be involved in state policy advocacy, or maybe work for state governments, very few states have their own non-discrimination laws, barring sex-based or intersectional discrimination in healthcare. A lot of states have disability-related civil rights laws. Grounds really vary, though. And so where feasible, we're trying to work with state advocates to push for robust state laws that either mirror or expand upon Section 1557's protections against healthcare discrimination. And we're here to support advocates in exploring what this could look like in your state, including how to ensure robust protections against discrimination in a sexual and reproductive healthcare context. Lastly, I shared some resources. We have a resource on why your comments really matter, as well as a number of resources on Section 1557, Section 504 in a sexual and reproductive healthcare context, as well as website state. And with that, I'm happy to take any questions.
Madeline, thank you so much for an informative talk. You obviously have deep domain knowledge on these subjects. We do have time for one or two questions, so anybody in the audience, please put it in the Q&A box. I do have one quick question. We know that Pride Week is coming up all around the country. In Philadelphia, it's the 1st of June. Could you speak to the evolution of non-discrimination protections for gender identity and where things stand now?
Yeah, so in 2020, the Supreme Court decided a case, the Bostock case, where they affirmed that sex discrimination protections under Title 7 of the Civil Rights Act, which is in an employment context, applies to sexual orientation and gender identity. And at the beginning of the Biden administration said, consistent with the Bostock decision, we are going to be enforcing Section 1557 to cover these grounds for discrimination. almost on, I think actually on day one of this Trump administration, the second administration, President Trump put out an executive order basically stating that sex discrimination protections do not cover trans people, put forth a vision of sex that really enforces a gender binary, which is not biologically grounded, and has since then been working to try and enforce Section 1557 rights against the inclusion of trans people in everything from education to healthcare. They've put in court filings that they are no longer going to be enforcing civil rights for trans, gender non-conforming and intersex folks, and they furthermore are signaling that they're going to be issuing a new final rule that will be rolling back implementation of these protections.
Thank you. One other question, obviously this non-discrimination advocacy is a personal thing for you. Could you talk about your own experiences with sex discrimination in the healthcare system and how they may inform your work?
Yeah, so I started experiencing chronic pain as a little kid and went decades without a diagnosis, had a lot of conversations with healthcare providers where they dismissed symptoms of vertigo and fainting and pain as anxiety. And this is an issue that is really endemic to the US healthcare system and Western medicine broadly. It's something that has really driven me to advocate for the broader movement's engagement on sex discrimination in healthcare, and is what really informed my advocacy to push the Biden administration to recognize that pain dismissal and undertreatment on the basis of sex is a civil rights violation. It was the first time that the federal government has ever made that recognized.
Yeah, it's so important with all of our trainees. We have to teach them, first of all, how to listen to the patient.
Yeah.
Because that's the first step to gaining trust. We only have a couple minutes left, so I just want to thank you, Madeline, for joining us and for educating us today about non-discrimination rights. Thank you to the audience also for joining us as well. This webinar is recorded and will be sent out shortly. If anyone in the audience is interested in joining us for your own Lunch and Learn webinar, please fill out the interest form. Thank you all very much.
Thank you, Andrew. And I'll just note, if folks want to discuss this issue further, please reach out. My email address is in the PowerPoint slide deck. So happy to support efforts to shore up protections.